Hello friends, in the series on the income tax cases, today we will discuss an issue that for calculating the limitation period of assessment under section 153A, which date of the last of the authorization of the search is essential. It may happen that for the search of an assessee there may be two search warrants. So for calculating the limitation period for completing the assessment, that is 1 year from the end of the financial year in which last of the authorization of the search is issued, whether the first warrant or the second warrant will be considered. This issue has been taken by Honorable Delhi High Court in the case of Anuradha, Bakshi versus Principal Commissioner of Income Tax, and this case is reported in 465 ITR at page number 786. The date of the judgment is 19th October 2023. In the present case, there were 3 lockers of the assessee which were searched by the revenue. According to the 2 search warrants, one search warrant was issued on 1st March 2021, and according to this search warrant, 2 lockers were searched of the assessee. One was in March 2021 and the second in April 2021. There was nothing found in these lockers. Panchnama was drawn for nil seizures. After that, one more authorization of search was issued on 5th April 2021, and according to this search warrant, third locker of the assessee was searched on 29th April 2021. And the panchnama was drawn of the even date. Now the question in the present case is that if the period is to be calculated for completing the assessment under section 153A, whether the first search warrant that was in March 2021 is to be considered, because if that is to be considered, then the limitation period will become 31st March 2022. Because 153 assessment is to be done within 12 months from the end of the financial year in which last authorization for search under section 132 was executed. And if the search warrant of 5th April 2021 is to be considered, and accordingly the last panchnama drawn date is to be considered, that was the 29th April 2021, then the limitation period becomes on 31st March 2023. The reason is that if we consider the second search warrant and the second panchnama that was in April 2021, the year end will be 31st March 2022 and 1 year from that will be 31st March 2023. So in the present case, since the assessment order has been passed on 31st March 2023, so the assessment order was well within limitation. In the present case, the assessee has filed the writ petition in the Delhi High Court for challenging the assessment order on the ground that it is time barred, because the assessee was calculating the limitation period from the first search warrant and the revenue was calculating the limitation period from the second search warrant. So Delhi High Court said that the period for completing the assessment is 12 months from the end of the financial year in which the last authorization for search under section 132 was executed, and an authorization is deemed to be executed on the conclusion of search as recorded in the last panchnama drawn. Delhi High Court also said that the limitation period of assessment warrants strict interpretation, and hence in the present case, since the last of the authorization was on 5th April 2021 and the panchnama was drawn on 29th April 2021. So according to that, if the period of limitation is to be calculated for completing the assessment under section 153A, that becomes 31st March 2023. And since the assessment order was dated 31st March 2023, so the assessment order is well within limitation period. At the end of this video, once again I am repeating the name of the case. The name of the case is Anuradha, Bakshi versus Principal Commissioner of Income Tax, and this case has been reported in 465 ITR at page number 786, and the date of the judgment is 19th October 2023. Thank you, friends.